So this slide lists some of the best practices to ensure that your arbitration are enforceable. Use a standalone document. Sometimes we'll see arbitration agreement in a handbook. That is not recommended. It's subject to change. There's case law that invalidate these types of agreements. If you do have it in a handbook, everybody has to sign it. I would further recommend that the places for the employee to initial off on key issues where they're waiving rights. Always use simple language. Avoid legalese as much as possible. Formatting issues come into play. The agreement should be in a normal size font, not a tiny font. Key provisions shouldn't be hidden. You could even consider highlighting certain key provisions in bold, underline, or larger font. We recommend make the agreement voluntary, not mandatory. An arbitration agreement is just like any other contract, so you want both parties to sign. A lot of times we'll see that the employer may not have signed. This is subject to challenge for lack of mutuality, and that the agreement is one-sided. That is one-sided. Highlight key issues being waived. I've listed in there: no jury, limited discovery, limited appellate review, waiver of class action. If you have, we often find that we've got employers with a large population of Spanish-speaking employees. In that case, I would highly recommend consider having a Spanish version available, or even an interpreter at the onboarding process to answer any questions of the employee. I will note that even a Spanish-speaking only or primarily employee, the case law is still enforces the English version of that. And they also have a clear enforceable severability provision. And do not forget, you've got to keep ongoing training of your staff on all wage and hour issues, including meal and rest breaks, and also maintain written records of the training. So some best practices on the maintenance and retrieval of arbitration agreements. This is critical. It pops up frequently in motions to compel. You can use a hard copy agreement or electronic agreement, but whatever makes sense for your operations. Usually electronic records are easier to store and retrieve, but whatever format you use, make sure it's accessible and the documents are complete. We recommend having all signed arbitration agreements maintained in one single central location, preferably in an electronic format. What you're going to find if you're involved in litigation is your attorney is going to be asking for that with very little notice, and you'll be scrambling trying to find things. And if you're having to go through individual records, you're going to miss that, and that's important evidence for your case. Also want to flag that if you're using electronic records, we see issues on that where we're trying to prove up that the employee actually signed the agreement. Now is a good time, to confirm with your online onboarding platform that you have full access to electronic signed documents. You've got a receipt or some audit trail that shows exactly when the employee signed. If you've changed a vendor, you want to make sure before you make that change that you get all of those electronic records. We run into that a lot where there'll be a transfer or a change in who you use. And so question, should I still maintain the signed agreement in a personnel file? I recommend that you do maintain it in the individual file as well as in the central location. And it's really important to track which of those employees who have not signed the arbitrations. And again, can't stress enough, have your arbitration agreements reviewed annually for needed updates.